Every so often, a legal case comes along that doesn't just, settle a dispute. It really shakes things up. It changes how we think about our rights, our communities, the whole deal. And today, we're diving deep into exactly one of those cases. We're taking a deep dive into District of Columbia v. Heller. That's the huge 2008 Supreme Court decision. And it tackles one of the most, let's say, heated parts of the Constitution, the Second Amendment. So our mission today, it's really to pull apart the arguments, look at how different legal minds read the same words and come up with totally different answers. We want to shed light on the history, the impact. We're not taking sides here. The goal is just to give you a clear view of what this whole debate is about. For this deep dive, we're going straight to the source. We've got the majority opinion from Justice Scalia, really powerful stuff, and the dissent from Justice Stevens, just as compelling, plus some great context from Emith and Karash to help frame it all. So let's jump in.
Yeah, it's fascinating because you look at the Bill of Rights and there's a lot of, well, let's call it vague language, abstract ideas, right? Freedom of speech, cruel and unusual punishment. We're always debating what those mean today, but the Second Amendment, for like 200 years, it was basically missing in action at the Supreme Court. Our sources even say it was conspicuously absent. It's pretty amazing that it took until 2008, until Heller, for the court to really weigh in definitively. So this case, Heller, it wasn't just another ruling. It really forced this old, unresolved constitutional question right into the spotlight.
And what a question. Okay, let's actually read the thing. The Second Amendment says, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Just hearing it, you can almost feel the tension in the wording, can't you? What are the absolute core issues that jump out from that sentence? How did Scalia and Stevens immediately go in different directions?
Well, that confusing language, as you put it, that's exactly the heart of the matter. It's why two incredibly smart justices could look at those same 27 words and, well, fundamentally disagree. The big fight is over those two main parts. That first bit, lawyers call it the prefatory clause, a well-regulated militia being necessary. Is that just setting the scene? Or does it actually limit the second part, the operative clause, which is the right of the people to keep and bear arms? And that leads right to the million-dollar question. Is this right individual something you possess for, say, self-defense? Or is it collective, tied only to being part of a group, like a militia? Justice Scalia, writing for the court, was pretty clear. He said the amendment protects an individual right to possess a firearm unconnected with service in a militia. And crucially, to use that arm for traditionally lawful purposes, such as self-defense within the home. For him, that militia part is just one reason for the right, not the only reason. It doesn't limit the individual scope.
Okay, so that's Scalia's take. Individual right self-defense is key. But Justice Stevens, in his dissent, he saw it completely differently, yeah. What was his interpretation?
Completely different. Stevens argued the Second Amendment protects only the right to possess and carry a firearm in connection with militia service. He saw that first clause as the controlling one. He basically said there was no indication that the framers intended to enshrine the common law right of self-defense in the Constitution, at least not through the Second Amendment. So yeah, two justices, same text, almost opposite conclusions about what rights you actually have. It really shows how interpreting even a short phrase can lead down vastly different paths.
Right, and that deep disagreement really sharpens when you look at how they dealt with an older Supreme Court case, United States v. Miller from 1939. It's kind of wild both sides use Miller, but they make it sound like two totally separate rulings. How does that even happen?
That's a great point. It shows how precedent itself can become part of the fight. Justice Scalia, well, he basically argued Miller didn't really limit the individual right much at all. He said Miller wasn't about whether an individual right existed, but about the type of weapon. In that case, it was a short-barreled shotgun. The Miller court said there wasn't evidence that that specific gun had a reasonable relationship to a well-regulated militia. So Scalia reads that and says, this implies an individual right could exist for weapons that do have that kind of relationship, which he connects to arms commonly used for lawful stuff like self-defense. He basically says Miller only means the right doesn't cover all weapons, just certain types.
And Scalia was pretty blunt about the Miller case itself, wasn't he? Calling it uncontested and virtually unreasoned. What's the significance of that kind of criticism?
Oh yeah, that's strong stuff in legal terms. Uncontested means the person fighting the government charge, Miller himself, didn't even show up to argue his side at the Supreme Court. So Scalia's point is, the court only heard one side of the story of the government's. And because of that, the Miller opinion had scant discussion of the history. For Scalia, this made Miller a pretty weak foundation to build an argument against an individual right.
Okay, so Scalia thinks Miller is shaky ground and doesn't really block an individual right. How did Justice Stevens then lean so heavily on it in his dissent, especially with Scalia pointing out those weaknesses?
That's the fascinating contrast. Stevens treated Miller as solid, settled law. He stated flatly that Miller held that the Second Amendment did not protect the right of a private citizen to own a handgun for self-defense. For Stevens, Miller was clear. The right is for military purposes, and it doesn't stop legislatures from regulating non-military gun use. He stressed that hundreds of judges had relied on this interpretation for decades, and it was even referenced later in another case, Lewis v. United States. He kind of brushed off Scalia's focus on the weapon type, saying Miller really turned on the basic difference between the military and non-military use of guns.
Wow. So the listener needs to grasp that even something seemingly settled, like a past Supreme Court ruling, can be completely relitigated, re-argued. That's huge.
Absolutely, it shifts the whole landscape.
So we have the fight over the words themselves and this battle over the meaning of Miller. But Heller also exposed this really deep philosophical split on the court, didn't it? A fight about how we should even, read the Constitution centuries later. Scalia was famous for originalism. What did that mean for his approach here?
Right, originalism. For Scalia, that meant interpreting the Constitution based on how people understood its words back when it was written and ratified, the original public meaning. So, applying that, he looked at historical evidence to support an individual right. But, and this is important, he also said this, right, like most rights, is not unlimited. He was really explicit about that. He wrote that the Heller decision shouldn't cast doubt on long-standing prohibitions, things like banning felons or the mentally ill from having guns, or forbidding guns in sensitive places like schools, or regulating gun sales. He also mentioned historically banning dangerous and unusual weapons.
So it wasn't a free-for-all view. Even the strongest originalist voice for the individual right acknowledged limits based on history. For someone listening who maybe just hears the headlines, what's the key takeaway from Scalia about those limits?
The key takeaway is that acknowledging an individual right, for Scalia, didn't mean throwing out all gun control. His originalism recognized that some restrictions were okay back then, or are logical extensions today, like not letting convicted violent felons own guns or maybe banning machine guns. It's more nuanced than just yes guns or no guns. It's about what kind of regulations fit that original understanding.
Okay. And Stevens, while maybe not a strict originalist like Scalia, he used history too, but to argue the opposite point. Right.
Exactly. Stevens dove into the drafting history. He pointed out that James Madison, the main writer, considered but rejected language that would have clearly protected civilian gun use. He mentioned a proposal from Jefferson, something like, no freeman shall ever be debarred the use of arms on his own property. Stevens argued that the fact Madison didn't include that kind of clear language showed the framers weren't thinking about a broad right for personal self-defense outside of militia service. It's like using historical silence as evidence.
But then there's a third perspective that came up in the dissents. Justice Breyer offered a completely different approach, moving away from pure history. He talked about an interest-balancing inquiry. What's that about?
Yeah, Breyer suggested a different path. Instead of focusing solely on history, he argued courts should use an interest-balancing inquiry. Basically, judges should weigh the government's reasons for a law like, say, tackling gun violence in a modern city against the individual's claim to a Second Amendment right. He pointed out that the problems D.C. faced with violent crime, while they were not when the Second Amendment was drafted, things are different now. For Breyer, the Constitution lays out broad ideas, and courts need to figure out how to apply them sensibly to today's world, balancing competing interests.
And Scalia's reaction to that, I can guess he probably wasn't a fan of judges balancing interests instead of sticking to the original meaning.
Oh, definitely not. Scalia strongly criticized interest balancing. He called it judge empowering, meaning it gives judges too much power to decide which rights are worth insisting upon based on current circumstances. He argued that the Constitution already did the balancing by listing the right in the first place. For him, letting judges rebalance it later makes the constitutional guarantee pretty weak, maybe no constitutional guarantee at all. He compared it to the First Amendment, saying the people decided free speech was important and judges shouldn't get to second-guess that balance. So yeah, a fundamental clash. Fixed meaning versus evolving application.
Okay, let's bring all this, the text, the history, the philosophy back down to the ground. The specific law in District of Columbia v. Heller. What exactly did the D.C. law do that sparked this whole thing?
It was a very restrictive law.
Yeah.
It essentially had a total ban on possessing handguns in your own home. And even if you legally owned another type of firearm, like a rifle or shotgun, you had to keep it disassembled or bound by a trigger lock at all times. Basically useless for quick self-defense.
Right. And that's where Scalia's majority opinion really came down hard. How did he connect his view of the Second Amendment to striking down those specific D.C. rules?
He directly linked it to self-defense. He wrote, "The inherent right of self-defense has been central to the Second Amendment right." He saw the handgun ban as prohibiting an entire class of arms that is overwhelmingly chosen by American society for that lawful purpose, self-defense. Especially, he said, in the home, where the need for defense is most acute. He also looked back at some old state court cases that had struck down really tough gun restrictions, arguing that history supported the idea that outright bans like DC's went too far. And on the operability rule, the trigger lock or disassembly requirement, Scalia said flatly, this makes it impossible for citizens to use them for the core lawful purpose of self-defense and is hence unconstitutional. He dismissed some historical examples Breyer raised about old colonial gun laws, saying those were just minor fines for, like, firing guns in the street, not severe criminal penalties like D.C. imposed for just having an operable gun at home.
It is important to remember, though, the court didn't strike down everything. They left D.C.'s licensing requirement in place, right? Assuming Heller could actually get one.
That's a crucial point, yes. It showed that even while affirming the individual right, the court wasn't saying no regulations are allowed. Things like licensing, background checks implicitly, those weren't invalidated by Heller. But Justice Stevens, in his dissent, was really worried. He felt the majority decision upsets that settled understanding that legislatures could regulate civilian gun use. He basically predicted it would lead to courts getting way more involved in making gun policy a far more active judicial role, because the ruling leaves for future cases the formidable task of defining the scope of permissible regulations.
Yeah.
And, well, he wasn't wrong about that.
Yeah, that seems prescient. So this deep dive into the legal arguments of Heller isn't just history. It connects directly to where we are now in our communities. The landscape after Heller is shaped by it. What do the numbers and more recent events tell us?
Absolutely. The context is vital. We're talking about a country with over 300 million people and roughly 300 million civilian-owned guns. Handguns make up about 100 million of those. Somewhere around 40–45% of households have a gun. And as we all know, it's an incredibly controversial and polarizing topic, especially after horrific events like the shootings in Newtown or Aurora. The sources also point out a pretty stark statistic. The U.S. rate of gun homicide is way higher than other high-income countries, like 19.5 times higher.
Yeah.
So Heller lands in this complex, often tragic reality.
And trying to address that reality through laws has been incredibly difficult, even when public opinion seems clear on some things, like the background check bills mentioned in our sources, getting over 50 votes in the Senate but not the 60 needed, despite huge public support.
Exactly. It shows the huge political hurdles. When Congress gets stuck, sometimes the executive branch steps in. President Obama used executive orders for things like better information sharing between states on gun records, promoting gun safety tech, like smart locks. And maybe, most notably, he directed the CDC, the Centers for Disease Control, to actually start funding research into gun violence again. There had been this congressional block back in '96 pushed by the NRA that basically gutted that research funding. It went from millions down to almost nothing. So restarting that was a significant move, trying to get objective data back into the picture.
It really highlights how this debate plays out across all branches of government and in society itself, long after a court decision.
For sure. Heller didn't end the debate. In many ways, it just set new terms for it, often pushing the fight back into the courts over exactly what regulations are permissible now.
So as we wrap up this deep dive, it's crystal clear, isn't it? The Second Amendment is just incredibly complex. You have these brilliant legal minds looking at the same history, the same text, the same precedents, and reaching fundamentally different conclusions about where to draw the line between individual rights and community safety.
Absolutely. Heller definitely clarified one big thing. The court affirmed an individual right for self-defense in the home, but it left so much unanswered. As Stevens warned, it created a huge task for future courts to define the limits. As Breyer pointed out, many specific gun laws and applications of the right remain uncertain. We're still figuring out the ripple effects.
So here's something for you, the listener, to think about. Society has changed massively since 1791. Technology, weapons, how we live, our understanding of public safety. And we've seen these clashing ideas about how to even read the Constitution, stick to original intent, or balance interests for today. So you might ask yourself, How much weight should we give to what the guys drafting the amendment were thinking hundreds of years ago versus the realities of life in America right now? What does it really mean for a right to be enshrined, kind of fixed in time, versus something that needs to adapt or be reinterpreted as society evolves? That's the ongoing tension, isn't it? And it's a question that's not going away anytime soon.